new here, I'm Tiffany Lesnick, a family law attorney who helps women stop post-separation abuse and start winning in court. Today we're continuing our 30-day legal reset, and this episode is critical because every message you send your abuser is either protecting you or becoming evidence against you. Because if you are dealing with an abusive or high conflict ex, communication is not neutral. Communication is evidence. Communication is leverage. And communication can either protect you or be weaponized against you. Today I'm going to teach you how to defeat your abuser in court using simple, strategic communication. No clever text messages, not emotional explanations, not silence. Clear structure and legal strategy. Let me say this clearly. Family court does not reward feelings. It rewards patterns, structure, and documentation. So rule number 1, no communication in person. You know this, right? Dealing with an abuser. We do not want to allow them to get us in a situation where they have us in person, because that is when the manipulation is the worst. So if you are still communicating with your abuser in person, you are handing them over power. Why? Because there is no record, there are no witnesses, and there is no accountability. And it gives him the ability to keep you there with him, to be able to talk and talk and talk and talk, right? You're going in circles with him. Abusers rely on plausible deniability. What does that mean? You know, when he comes back and says, I never said that, she's exaggerating, or she misunderstood. One of the things that my abuser used to do, because I'm also a survivor, is because he would speak something into existence. He would say it out loud. It meant that I agreed, or it meant that we were absolutely going to do something. He would just speak it and it would be so. We do not want to put ourselves in a position where we are in person with them. We also don't want to get on the phone with them. They will use manipulation to say this written communication is a waste of time. You need to call me. Call me right now. I need to talk to you. We do not need to talk to them on the phone or in person. Communication with a coercive controller needs to be in writing only. That means email, court-approved apps such as Our Family Wizard or Talking Parents, and text message if necessary, and make sure you're preserving those text messages. No hallway conversations, no conversations at the coffee shop, no driveway discussions or discussions in church or at exchanges. No emotional confrontations at exchanges. Every in-person interaction is a risk for you, not a resolution. So rule number 2, we want to use yellow rock communications with him. You've probably heard of gray rock. Gray rock says, say nothing, be boring, disengage. This sounds good until it comes time for court, because silence can look like cooperation, withholding information, parental alienation, bad faith, rudeness, disagreeableness. Instead, I teach yellow rock. I call it my kill him with kindness method, but yellow rock is similar. Yellow rock is still neutral and brief and informative, but it's also polite. You're not communicating with emotions, you're not communicating with explanations, and you're not defensive. So let me give you an example here. You're upset because he's late for an exchange and the children are stressed out. So you send him a message that says, you're always late and it stresses the kids out, period. That's not the kind of message we want to be sending. Instead, we want to rephrase that and send a message such as, pickup occurred at 6:42 p.m. Please confirm future pickups at 6 p.m. per the court order. Very brief, neutral, informative. We also don't want to give the abuser additional information, because if you send that first message, you're always late and it stresses the kids out, right? He wants to inflict pain. He wants to inflict chaos. So if he knows that by being late, everyone's stressed out, he's more likely to continue that pattern of behavior. We also want to use our messaging, our communications with him as kind of like a journal. We are documenting for the court. So that second message is so much better because it tells the court exactly what time he picked up the children, which was 6:42 p.m., that he was late, and that he's not following the court order. And you are asking for him to please comply with the court order, and courts love compliance with their orders. So Yellow Rock creates clean evidence, and it's going to benefit you. So rule number 3, use artificial intelligence for help. You can use ChatGPT or Amy Says, which is geared towards domestic violence communication. This is something I teach inside my Live Free legal coaching groups, how to use AI to help with your communications. You do not need to write responses alone. AI can help you remove emotion from your messages, shorten your messages, convert your messages to a Yellow Rock method, reframe your messages for court, help you stay consistent in your messaging, avoid reactive language. And before you send, put your messages into AI and give it a prompt, such as rewrite this to be neutral, factual, and court appropriate, or rewrite this in a Yellow Rock format. AI is not replacing your voice, it's protecting you and your children, it's protecting your record, because written communication is one of the strongest forms of evidence in court. If you want to learn more detailed information about how to use AI to draft your communications with an abusive ex, go back and watch some of my other videos. I have a whole series on using AI in post-separation litigation abuse cases. We have some of the links, so you can go back and watch those videos in the description below. And by the way, give us a like and a thumbs up and subscribe to the channel so that you can get access to more informative videos like this, and so that we can get this messaging out there to more women who need to hear this. So another thing you can do in your communications that are very important is to set boundaries. So we want to tell him, please stop texting me, or you've texted me too much. I need a response from you within 24 hours. We want to absolutely set boundaries with him in our messaging. But a boundary without a consequence is just a request. And a request without enforcement is meaningless to an abuser. It just says she's going to say whatever she wants, but she's never going to follow through with it. There's never going to be any consequences, so I'm going to continue to behave however I want to behave. So here's some boundaries that work. These are also boundaries judges are going to respect and not hold against you. So make sure that your boundaries, one, are always written so that you have proof and documentation that you've made boundaries. They need to be specific. What is it that he needs to do? I will meet you at the local police station for the exchange. The where. They need to be time limited. So again, give him a deadline. Maybe a decision needs to be made so that your child can attend a specific elective or a specific extracurricular. Give him a time specific to respond to ensure that your child will be able to participate in that activity. Or maybe you need support by a particular day so you can pay your rent or pay a particular bill. Make them order-based. If you have a parenting agreement, a separation agreement, or a court order, make sure you're deferring to the language in those legal documents and defer to those specific provisions, and make him follow through on what he is legally required to do. So, for example, written communication only, defined response times, no in-person meetings or exchanges, order-based communication platforms such as our OFW, be using those, and then log any violations. These are legal boundaries, not emotional ones. Rule number 5. Keep a calendar and keep him informed. This is so important to legal custody. So legal custody is decision-making authority or power. So many of my clients want to be able to have sole legal decision making because abusers generally don't care when it comes to the children. Many times they're going to interfere with therapy and medical care and education. And my clients want to have sole legal custody, but they don't want to keep the abuser informed because they're afraid he's going to show up at that parent-teacher conference. He's going to show up at that doctor's appointment. He's going to make a scene. He's going to be embarrassing, or they're going to be traumatized or triggered by his presence. And you know what? He might. He probably will. He probably will show up at that parent-teacher conference. He probably will show up at that doctor's appointment. We need to let him. There is a long-term goal that we are trying to achieve here. So we need to set him up for long-term failure. And to do that, sometimes we have to experience some discomfort in the short term. We need to let him know. Email him, set up a calendar, give him access to that calendar, and let him know this is when these conferences are going to occur. Put it on the calendar. This is when the doctor's appointment will occur. Put it on the calendar. Give him an update about what happened at those appointments. And why do we do this? Because if he shows up, the doctor is going to document his behavior in the record. We can then use the medical record as evidence in a future hearing to try to get you sole legal custody if he's showing up and acting like a fool. Right? If he's interfering with parent-teacher conferences or IEP meetings, that is going to go into the record. We can then use the school records to help you gain sole legal custody. If you're not telling him about these appointments and he's not showing up, we do not have an accurate reflection in the record of his behavior because you're constantly coming in, swooping in to save the day so that your children experience no dissonance. And while that's good and noble, that hurts you and it hurts your children long term. So we've got to allow him to be who he genuinely is for at least a short-term period of time so that we can make a long-term impact in our children's lives. And I know that's so hard for my clients. It was so hard for me as a victim going through this. I wanted to save my children from everything, but you end up looking bad in the process, right? It looks like you are the one who is withholding information. He then's going to accuse you of parental alienation, that you're not fostering a relationship between him and the children, right? That he should have equal custody. So we don't want to do that. So many women think I don't need to tell him anything. And legally, that's often wrong because courts expect transparency, consistency, good faith, even when the other parent is abusive. So create a shared calendar. Put things like medical appointments, school events, therapy, activities, and share that calendar with him so you limit your interaction with him. Say, hey, I'm sending you an email. Here's the shared calendar. Everything is on there. You're able to access it anytime you want. The other thing I encourage my clients to do is make sure he's on any Gmail or Google List or listservs at school or through the extracurricular activities. And make sure it's clear that you've shared that email with him or you've shared his information with the teacher or a coach or whomever that is so that you can testify to the fact that he's had joint access to the listserv or to this email for school or for the extracurriculars, right? So you're not having to give him updates all the time. He's just automatically on that email listserv or that calendar. It shows that you are reasonable and it shows that you're not trying to alienate him from the children, and it exposes his non-involvement or his manipulation. We need to have that evidence, okay? And then when he claims she keeps me in the dark, you pull out that calendar, you pull out those emails. Evidence beats accusations every single time. So, the next rule, ignoring him does not work. We don't want to have to interact with our abuser. It's very triggering, it's very traumatizing. This is the hardest truth. Ignoring an abuser does not make them stop. It often makes them escalate, file motions, make accusations against you, rewrite the narrative, silence is not a legal strategy. Sometimes it's going to be uncomfortable, but again, we're looking at the long-term gain. So I'm gonna pull this from behind me. Hopefully y'all can see this. I've got my scales of justice here. And what I wanna show you why communication is so important and why you need to be above reproach when it comes to your communications. So let's say he sends you a scathing email, calls you names, cusses at you. It's gonna go in his scale. And hopefully you can see what happens to the scale, right? His side goes down. And then you respond in kind and talk about how abusive he is and what a horrible father he is, and you just boop, 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 down. You're not responding yellow rock. You're just getting right into it with him. So your message on the scale looks just as bad. So what happens? The scale is equal now. So the judge is looking at him and his messages are horrible, and he's looking at you and your messages look just as bad. So you guys look equal. So then he sends another rotten message, right? The scale again goes down and you go up. You look a little better because he sent more nasty messages. But now you send a threatening message. You threaten to take the children from him and he's never gonna see them again. Now you guys are equal. What we want to do, why communications are so important, is that he's gonna send you message after message after message after message after message, right? And we're not responding in kind. And by doing that, he goes down and you go up. So when we come to court, we want you to be way up here and we want him to be way down here. So when the judge is evaluating who the better parent is and who they should give legal custody to or physical custody to, you are all the way up here and he's down here. We don't want you to be equal. And that is why communication is critical when it comes to evidence in the courtroom setting. So hopefully that illustrative helped you. So let's recap. To defeat your abuser in court through communication, no in-person communications, use yellow rock, use AI to protect your tone, keep a calendar and document transparency, stop burying your head in the sand, and anchor boundaries in court orders, parenting, and separation agreements that you have. You don't win by reacting, you win by outlasting and out-documenting. If you want help implementing this step-by-step, if you want scripts, templates, AI prompts, and legal strategy, join my Live Free legal coaching group. They are 12 weeks long and we dive deep. They start February 3rd. Registration for these groups ends this week, January 31st. So if you want to get on board with a coaching group that will dive deep in how to defeat your abuser in court, you've got to register now. The groups are only $35 a week. They last for 1 hour. Tuesday evenings at 8 p.m. and then we have a Q&A that follows. This is a group with me live as your instructor. This is not a virtual group. The link is below if you want to get registered. Also, remember to watch my videos on using AI to help defeat your Goliath in court. The links are below to access those AI videos as well. Before we end, I want to remind you of this. You are not crazy. You are not imagining what you've lived through. God is a God of truth, order, and justice, and nothing that thrives in darkness can stand forever in the light. Join me next time, Tuesday at 7 p.m. right here on YouTube at Live Free Legal, as we post a video every week at 7 p.m. Eastern Standard Time. Remember to like us, give us a thumbs up, and subscribe to the channel. See you next time, and God bless.